Hi, hello, namaste, good morning, good afternoon, and good evening. Today I'm here again with immigration attorney to just clarify all the doubts regarding H1B cap registrations, refiling, and all EAD and everything. So, without any late, let's invite Mrs. Janetha Garu. So, namaste, madam. Good afternoon. How are you?
Good, thank you, Lakshmi Garu. How are you?
Yeah, fine, Andy. So, yeah, ఎందుకంటే now anyway we have got the time for all the H1B immigrations, visas, and everything, right? So, like from already the time started to apply for the visas, registrations for the H1 visa, and waiting for the lottery time, right? So,
That's correct.
yeah, so I've got some questions for you and some doubts from different callers and different friends. So, let's
Mhm.
start the interview. So, anyway, it has been announced that the initial registration for the fiscal year 2023 will be between March 1st to March 18th. So, could you explain this?
Yeah, I mean, this new electronic system was introduced
Mm.
2 years ago, and then
Right.
this is the third time that we are doing online registrations.
Uh-huh.
For this fiscal year, I mean, on before February 20, sometime in February, USCIS, they came back and said that yes, 21st, accounts can be registered, like employers in the accounts, if they never had any account, they can register starting February 21st. And then
Uh-huh.
starting March 1st noon, the
Uh-huh.
registration period is open from March 1st sharp noon to March 18th sharp noon. That's a time frame, when employers, attorneys, everybody, whoever wants to be in that pool of lottery, they should go ahead and register.
Okay. Okay. Yeah. So, madam, we have got a call. So I think they want to ask, they have doubts some regarding H1 visa and H4 EAD and everything. So, let us take the calls. So,
Yeah.
hi, who is on the line? Hello? Hello? I think the callers are on mute. Can you unmute it and please talk to Mrs. Janetha Garu and ask any doubts you have? Hello.
Hello, Andy. This is Shilpa.
Hi, Shilpa Garu. Yes. Today we have Janetha Garu. Could you go ahead and ask the doubts you have?
Sure. Hello, Janetha. How are you?
Good, thank you, Shilpa. How are you?
I'm good, Andy. Just a quick question, Andy. Just based on the current employment-based green cards that are moving pretty fast currently, are they moving fast currently, or how is it actually working out now, Andy?
I mean, if you could see from the past, few months, I think EB2 is, consistently moving forward, 6 months ahead of time. So I'm
Okay.
not really sure how the next bulletin is going to be, but, we don't see much movement on EB3. So, but however, if you could, go back and then see the announcement from the USCIS that they are stating they have, more numbers in the EB2, and then, they want everybody to do an interfiling whose numbers are current on, under the EB2. So, like pretty much, as you know, the in 2020, December, October, it all started with the September bulletin. Everybody started downgrading from EB2 to EB3. So now we are doing a lot of interfilings. There is a specific announcement back in February that how to do an interfiling, and the USCIS also gave out a separate address in California, saying that the interfiling should be done at that address along with the 485J supplements. So we already started doing that, but I mean, we never heard back from them nor the 485J receipt notices yet. But that's what they said, and then I mean, let's keep our hopes up at least that they'll try to use the numbers that they have this year, unlike last year.
Right. Okay. Thank you.
You're welcome, Shilpa.
Thank you so much, Shilpa Garu, for calling. So we have another one more caller on the line. So let us take that call also. Hi, who is on the line? Hello. We have a call with the number 7732. Could you please unmute and call? Sorry, could you please unmute and talk to Janetha garu? Hello. Okay. I think they are on mute. Madam, let's go with the next one.
Mhm.
So, how do the beneficiary apply for the registration and what are all the important documents they need to submit?
Yeah, I mean, it's not actually the beneficiary who will be eligible directly to register on the
Mm-hmm.
H1Bs. It's the employer who is sponsoring, who is stating that, he does
Okay.
have a readily available employment opportunity, for that particular beneficiary, and they need a resource. So what they do is, with the basic information like, the first name, middle name, last name, along with their passport and the date of birth, and also, whether one will come under the master's cap or a bachelor's cap. If they have a United States master's degree from a recognized university, they can go ahead, the
Mm-hmm.
employer will go ahead and then register them under the master's. If not, any US bachelor's or, a bachelor's from any other country would come under the bachelor's cap. So,
Mm-hmm.
that's how the registration goes. Either the employer or their HRs, or their authorized, personnel can go ahead and register.
Mm-hmm.
Usually, employer will pay a $10 fee to the USCIS per person for registering the candidate. And once all the registrations are done, and then the registration period closes on 18th, I
Mm-hmm.
think most likely, as per the USCIS statement, they said most of the corporations will be notified at least by March 31st. So
Okay.
starting if once employers are notified, like, hey, these are the applicants that are part of the lottery pool, and then those who got selected, then
Mm-hmm.
employers will have the opportunity to actually file the application for 90 full days, like the whole April, May, and June, 3 full months.
Okay.
So
Mm-hmm.
within that time frame, they can go ahead and file the actual H1B with the USCIS. So technically,
Mm-hmm.
by June 30th, the petition should be with the USCIS.
Okay.
So,
Okay.
which
Got it.
technically, they got a lot of time to actually file the paperwork. 90 days is a lot of time.
Okay. 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 Madam, we have another caller on the line. Let's take the call. Hi. Who is on the line? Hello. Uh, could you please unmute and talk to Mrs. Janetha garu, please? Hello. The number is 5548. I think you are on mute. Please unmute it. Unmute the call and talk, please. Okay. So let us go for the next question before they talk. So yeah. So once the registrations are accepted and the process starts, so like when are all the petitioners or the employers will be notified whether the application is selected or not? How much
Yeah, I
time does
mean,
it take?
yeah, I mean, March 18th noon is the deadline that they
Yes,
will be closing the registration. And then,
right.
as I just said, March 31st is the likely date. Maybe we can even see even before that one, because usually once the registration is closed,
Mm-hmm.
as per what most of the employers and their attorneys witnessed past 2 years, even slowly before March 31st, we see slowly trickling down of the
Mm-hmm.
petitions that are being accepted, in the form of the emails, and also you can just log into the account and then see who is
Mm-hmm.
part of that, selected, from the
Right, right.
lottery. So
Yes.
that will happen before, I mean, at least before March 31st.
Okay, so let us think it's March 31st. Is there any delay in the date? Because sometimes we may get more applications as expected, right? So, for
Yeah,
example,
yeah.
yeah. So
I
let us
guess
think
this
this year
year.
we are expecting more than
Mhm.
50,000 something, some whatever is the number. So if we receive more than the count what we are expecting, will there be any delay in selecting the applicants or notifying the applicants, or 31st is the last deadline date to announce?
No, I mean, usually there is always more numbers that they will have.
Right.
So, past 2 years, if you're, seeing as per the electronic register, even before that one, if I remember correctly, it's once in 2012, the lottery was like kind of not really, they had to, the petitions, I think, petitioners, the numbers were actually there, if I'm not wrong, sometime till June or so. And after 2012, it never happened. Always it is 1:2, 1:3. And from our law firm, we are definitely witnessing, a higher registration, numbers. So I believe that that's with everybody. So this year we might definitely see, the more percentage wise, because there's 20,000, quota for the masters, and then the rest 65 for the bachelors. So what happens is, as soon as the numbers are, there is no doubt that numbers won't reach. Definitely it's going to be more than 1:3 this time. That's what I'm predicting. So as soon as the March 18th noon is done, they will run a lottery, and then they'll start notifying. They'll do the master's lottery first for that 20,000. Let's say for 40,000 for the 20,000 of master's quota, if they receive 60,000, hypothetically, right? So they'll select that 20,000, and rest of the 40,000, whatever is remaining from that 60, they will again put them back into the bachelor's cap, and then they'll run the lottery. So which technically means that a person who is having a United States master's degree will be having an advantage. So, they will have a double dipping in that lottery. So they will have a higher advantage. Most likely it will get picked up.
Oh, very nice, ma'am. So, and what are the H1B specialty occupations?
Yeah, H1B itself is a specialty occupation. So, technically these H1Bs are like, you are saying that we don't have enough skilled personnel inside the United States, and then, would like to bring it from outside, or, hire them on that specialty occupation. So then you are sponsoring them, these H1Bs, and then all these lottery and all. Then eventually you'll be given the chance to submit the paperwork. And then, it all depends upon case to case. It's not, most of the time, if you have all the paperwork, yes, you'll have a smooth sail and having an approval on those lines. But, if you are not like, let's say, if you have once the employer submits the petition, and then the title is, let's say, a software developer. And then if this particular person is having a master's or a bachelor's in, something other than a degree, other than the master computer science, possibility is there that they might, see an RFE. So technically these days we are witnessing a little bit of the RFEs, especially on the specialty occupation category. They're asking how this person is a best fit for this particular job, how he will perform, what are the underlying requirements for this particular job, whether it requires a bachelor's or a master's, and then if so, major in what, how many years of experience. They would like to see all of these things. This is all nothing new. It's all right there since the inception of the rule. But however, give and take, year in and out, these interpretations kind of like, we can see sometimes, RFEs on the specialty occupation, and then, sometimes on different things. Each and every year you witness different kinds of RFEs that, most likely they will, especially this year, if we are looking into 2022, on the transfers and then H1B extensions and the amendments, we are seeing there is a little raise on the specialty occupation RFEs. So if a person is not having a computer science degree, and then if the job title is related to a computer science related background, then you definitely are receiving an RFE for that, asking you to explain how he's the best fit into. So you respond back to the RFE, with breaking down, what are the client requirements, and then, and what are the qualifications of the, the beneficiary, and then how he meets that requirement of the client, and then if required include an expert opinion from an expert who talks about how his coursework, like in the masters, how that coursework is related to his job based on the LCA and stuff like that. A lot of detail going there.
Okay, okay. So, madam, nowadays the H4 EADs and H4 visas are getting delayed, right? So, what can one do when their H4 processing is being delayed?
I mean, unfortunately, we are witnessing very high level of backlogs, especially in
Mm-hmm.
the H4 adjudications.
Mm-hmm.
Previously, they used to, like, if the husband files the H1B, like, not the husband, but, if the principal applicant files the H1B along with the derivative beneficiary, whether it is a, he or she. So kind of they used to give, that kind of, if they file in premium process, both H1B and H4 usually used to get adjudicated in a premium. But we don't see that from the past more than 2 years. So H1B, of course, is getting adjudicated in that premium process, and then H4s are getting delayed, and a huge backlog we could see at least 18 plus months. We are witnessing. So, but of course, however, whatever was filed after September of 2021, we are
Mm-hmm.
seeing that they are kind of going a little bit faster on those lines, like at least sending the biometric notifications if required, if the biometrics were not recaptured and stuff like that. But however, one should really evaluate, where they stand, whether they really need to do a H4 within the country, or once the spouse, because H1Bs are eligible to go for extensions 180 days before. So they
Mm-hmm.
do have that buffer time to make a decision, like, once the principal applicant's H1B is approved, then they can make a decision, or like, whether to go outside the country, go for stamping, and then come back in based on their situation, or, just stay put inside the country, just go with the H1B, H4, and EAD. A lot of things are, I think, especially because of the lack of staff, you could clearly see these huge backlogs. And on top of that one, especially these days, if you are filing in premium, highly likely you will be getting an RFE, because they are using it as a time buying technique.
Mm-hmm.
Just to put it aside, because of course they are charging 2,500 for the premium, and then keeping it aside because lack of staff is not a great justification.
Mm-hmm.
The kind of money employer is paying for, the service they really want, they really introduced. If I recall it properly, I think in 2020 sometime, the Congress has passed a bill stating that they can charge more, or to certain areas of, like H4s or EADs, they can introduce premium process. Though that bill was passed, they kind of have gave that guidelines to the Department of Homeland Security to go ahead and then introduce it, or come up with specific regulations within 180 days time.
Mm-hmm.
And we still don't see that. And then a lot of people are willing to spend that kind of money on EADs, especially because if one is working on H4 EAD, and then these delays especially are hugely impacting their work. So people are willing to spend, if the DHS comes up with a proper guidelines on whatever the amount for the premium process for these. I think people are waiting for a
Yes.
while, but it's never been introduced, or guidelines were never framed. So it's kind of totally, if you can look into, it's kind of everything is backlogged. And then especially we can also say due to pandemic,
Mm-hmm.
also the level of cases that got increased. And everywhere, even with the Department of State, people like want to come here. They are looking for the slots, whether they are available or not, especially B2s, if they want to come, go for visas right now, they are not available. And of course, at least, Department of State introduced, this, your one is eligible for just doing it by, if they previously had any type of visa, they are eligible for this drop box. So that is at least, benefiting a certain crowd that who previously had. But again, a lot of cases pending with the USCIS and with the Department of State. And then, I guess they are still trying to streamline both the processes.
Right. So, yeah, few more questions are there. And till here, do you want to add any more important points for all the H1B cap registrations who are applying for that?
I think pretty much, cap registrations, especially one should really, keep in mind is sharp March 18th noon, because, after, it's 12, not even 1 second, the system will be, after 1 second, the system will not allow you to register actually. So, one should be mindful of that one, and then, go ahead and register ahead of time. So that way, it will be part of the pool, and then, within the next 10 days time frame, by March 31st, USCIS will notify, and then, people will start knowing, and then, everyone will be given 3 full months time frame, 90 days, to file the paperwork. I don't think other than this one, there is any additional thing that I would like to add on this topic.
Okay, sure. And madam, so the lottery, like H1B lottery, is based on wage levels. So is it applicable for this fiscal year 2023?
No, it's not.
Okay. So tell me. Yes. So and what is the filing fee for the H1B visa?
You mean for the registration process? You mean to say?
Yeah, because it has been mentioned $10. Is it the same, or there is any change for the fees?
No, it's a $10 USCIS fee that employer will be paying per applicant, and then then they will register. So that is only for the registration process. And once the petition gets picked up, then based on number of employees and all, that fee will vary from employer to employer.
Okay, thank you. Okay, we go. Yes. So let's moving to the next one. Where should a petitioner with a selected registration file their form I-129 and supporting documentation?
Yeah, starting from April 1st. So, you will have full 90-day time frame that, you can file the paperwork with the USCIS. So it can be anywhere from April 1st to June 30th. So bottom line is by June 30th, the petition should be in the USCIS hands. So, but I definitely encourage filing ahead of time, because, really don't wait till the last minute. So, these days we are seeing sometimes, a lot of delays in delivering, especially from the FedEx side, because, you do experience that when you are practicing, and then it's kind of crazy, missing the deadlines. So it's always, employers be mindful of the deadlines, and then, sending them out properly as per the guidelines for the USCIS.
Yes, ma'am. So we have we have discussed about the H4 visas and EADs, right? Yeah. So can you also please explain more on H4 and H4 EAD, because many are having doubts that the people who have a H4 EAD, they are eligible to work in any company or do anything, right? And some more doubts they are having. Can you please explain us about H4 EAD who are eligible to work, and when can all the pending documents like pending visas or pending EADs will be clarified?
That's a good question, but nobody has insight how many cases they do have, especially the H4 EADs. And as I said, a lot of cases got backlogged, and then people even try to file some of the lawsuits. Some of them are successful, some of them are not. So,
Right.
based on the recent, settlement with the USCIS, whoever is having the underlying I-94, the H4 I-94 validity, based on the receipt notice, they can continue working. And then there was a big relief for the L2 EADs because, they just don't have to do anything. They can, as long as they are on L2, they can just go ahead and work. That is another thing. But however, this agreement is not really benefiting the larger crowd, I would say,
Right.
because most of them will be filing the H1B extensions with the principal applicant and then the H4 and the EAD at the same time. And then, the underlying I-94 would expire at the same time. And then, one is definitely eligible for the extensions 180 days before, though they are doing it. There is at least, we are seeing delays, but with this agreement, a little bit relief for, some applicants where they have the underlying, I-94, on the H4, and then they can show that validity time frame and then, work. And especially when it comes to this H4 EAD, there are no strings attached to this EAD, unlike the, OPT EADs that the students have. So, they can work in any industry, anything, they can do anything pretty much they want to using that EAD as long as they are performing the legal work. So, they can even establish corporations as well that, most of the time, we see that. And but if one is trying to establish a corporation on the H4 EAD, they also need to consult an immigration attorney and the corporation's attorney how it plays out, and then who is going to be the major shareholder, and then because there should be no gaps in between the H4 EAD if one is establishing a corporation and trying to run that business, because if he or she is the owner, then that continuity should be there. The status continuity, the working status continuity. So, but good part is that no strings attached, unlike the other EAD. So pretty much they can do at least experiment doing things with the H4 EAD. But unfortunate thing is because of the backlogs, most of the people are at times even losing their jobs as well because of these. And unfortunately, you can try to expedite, but USCIS is not really willing to expedite unless and until you meet certain conditions. There are some exceptions to it as well, like for the healthcare workers, who fall under this category. They are doing the extensions for them, like kind of doing the EAD approvals for them. Based on that, if you had to specifically, let them know this is what the situation is, or chat with them and then, do an SR and things like that. Provide the USCIS proof that you are, actually a healthcare worker, and then, that's how things are being adjudicated. And same is applicable for the adjustment of status pending 485s, EADs as well. Like, people, those who downgraded, they received EADs, and then again, some of the people who wanted to interfile, they did, and then some really wanted to refile, they did. And then, those EADs, like, for each and everything, you had to really, go back, because that streamlined process you are not really seeing because of the lack of staff and huge case backlog.
Okay. Got it. Yeah, and now we have a caller. Let's take the call. Hi, who is on the line? Hello? Yeah.
Hello, are you able to hear me?
Yes. Please go ahead and you can talk to Janetha garu.
Hi, Janetha garu. Thanks a lot for helping the community, Andy. I have a quick question, Andy. We have priority date of June 6, 2011. Unfortunately, we missed it by 22 days, so we downgraded it in the month of December 2020. And we got the biometrics done last year in the month of June. We got EAD, AP approved. We received it in the month of August, and I-140 was approved in the month of September. And in the month of October last year, our case was moved from Nebraska Service Center to National Benefit Center. It is just gathering dust there since 5 months, I can say. And we already used the EAD and the AP since November 1st for myself and my spouse. Now our question is like we are dilly-dallying, or we are a bit confused and unable to decide whether to enter file. Anyhow, we don't have the option to refile, and we don't want to spend money to be honest with you. So we don't. What are the chances? Like if we enter file, will it delay our process, or should we stay put because our application is in NBC since 4 to 5 months?
Say for the interfiling, it won't cost you anything. Maybe you had to pay the attorney fee, but the USCIS fee, there is no cost involved in it. So definitely, if you are eligible for that one, I would recommend filing, doing the interfiling. But however, being honest with you, as we started doing the interfilings, till date, we haven't received any receipt notices for any of the 485Js that we filed for, nor the employer, or us. So, not really sure, what would be the USCIS plan on those lines, but at least, they have a separate address for that, for the interfiling, and then, looks like actively they are trying to send a message stating that instead of refiling, because, if you are assigning a resource to the complete file rather than that, interfiling would be kind of, a lesser hour, less work, right? So I think that's what they are trying to encourage. But, there is no outcome as well so far. But, but once people start seeing these 485J receipt notices, then I think most of them will be willing to. But I would say, there is no, it will not hurt you doing an interfiling. So definitely, if you are eligible, go ahead and do it. So that way, both will be considered, whichever comes first or picked up first, unless and until, they have kind of an RFE, and the case will wait for, the interview scheduling at the local field office.
Okay, actually, we went through the congressman too, and now we are trying to go to the Senate member too, saying that we are here since so many years, and we have spent a lot of time, and still we are waiting for the green card. So we are giving it. Am I allowed to ask one more question? And it came just yesterday. Yeah, I think that this is regarding our in-laws green card, Andy. Actually, my brother-in-law and sister-in-law, they had applied for our in-laws green card. I think when they applied for the green card, there was a question saying that are they legally in US right now? Because they were in India, they mentioned it as no. Right now, they are not in US. And later, a few days back, they received a notice from USCIS. Regarding scheduling the interview in Indian consulate. Now our question is like anyhow they are planning to come over here to US. Is there any chance to switch that consular processing in US to interview in embassy in US so that it will be easy for them?
Yes.
After they land in US within a month or so?
Yes, they can do so. I'm assuming they do have a valid B2, so to come over here. So now the first step is already completed. The I-130 application is done, and then now the USCIS communicated kind of to the NVC, and then NVC is the one who plays a role in getting all the documentation and then doing the interview dates at the Mumbai consulate. But of course, if they are planning to come here, yes, they can come here, and after they land here, they had to file for the adjustment of status. It's not that they will change the same process within the country. You have to leave that first part there and then say, as they are already inside the country, now they will be filing their own, like, your mother-in-law and father-in-law, they will be filing their own adjustment of status within the country, showing the proof of the I-130 approval. So that way, once this adjustment of status is filed from B2 to, the adjustment of status, then they will get an interview, within the country. And then keeping their age group in mind, sometimes, they might not be, interview as well, just collecting the biometrics. Sometimes there will be a waiver of biometrics as well. It all depends on case to case, but as absolutely they can, do an adjustment of status as, once they land in the country.
Yeah. How long will it take, Andy? Like once they enter US and if they switch it, the process, how long does the process take?
It's anywhere between, I would say, 6+ to 8+ months, depends upon, the where they are geographically located, because if they had to schedule an interview, if it is a metro city, maybe, more time frame. But, at least 8, and on an average, no matter which city it is, at least 8+ months.
Okay. So, but basically, there is an option to switch from Indian embassy, Indian consulate.
It's not switching. It's not switching. As I said, it's not switching. They will leave that process there, and then as soon as they come here, it's not as soon as, but once they land here inside the country on a visitor's visa, they are eligible to file the adjustment of status, which is a separate process.
Okay. Thanks a lot, Janetha. Appreciate that, Andy.
You're welcome.
Thank you.
Thank you so much, Andy, for calling. Thank you.
Thanks,
And
Andy.
we have one more caller. Let us talk with them. Hi, who is on the line?
Hi, my name is Krishna Sai.
Hi, you can talk to Janetha garu.
Hi. Hi. I have a question, ma'am, actually. I have applied both downgraded my EB2 application to EB3 in October of 2021, actually. So after that, EB2 dates went back, and EB2 dates came forward, and EB3 came back, actually. So what is now is like I have applied to interfile to again go back from EB3 to EB3 to EB2, but my EB3 I-140 is still pending with Nebraska Service Center. Wanted to know, like, does USCIS approve adjustment of status if you have a downgrade pending, or what is it going to happen, ma'am? If you
you said you downgraded from EB2 to EB3, right? And then 3 I-140 is still pending. So which technically means that though the EB3 I-140 is still pending, you already have a EB2, I-140 approved. So when you said that, okay, they downgraded it, and then I'm assuming if they downgraded EB2 to EB3 and then requested a reclassification, then if they haven't amended, then definitely they can, do an interfiling, or, you can, refile the whole thing. But as USCIS guidelines came, they are trying to ask most of the people to, do an interfiling. Yes, as long as, just have a conversation with your corporation immigration attorney, and then most likely you'll be eligible for the interfiling. So for the interfiling, technically, they will be needing all your 485 receipt notices and another 485J confirmation of the bona fide job offer from your current employer. And then that's how they will be sending the whole file, to the California center, that address which was created by the USCIS.
Yeah, I have interfile, ma'am, because my current in from March 1st. But the thing is, like, because my EB3 I-140 is still pending, ma'am, I'm still in a confusion. Does USCIS adjudicate my adjustment of status based on my approved EP2, or they just will be, in limbo and just,
No, if you do recommend? If you do an interfiling, for, the EB2, definitely, as you are just bringing your 485 from the EB3 and then, asking them to adjudicate under, EB2, because you already have an I-140 approval under the EB2. And then rather than filing another 485, you're bringing the whole 485 file here and then adding it on the EB2 front. So technically, I think, it is a doable one, and then that's what you should do.
Okay, ma'am. Okay. I just wanted to, because everybody is in a confusion. Like I have, like myself, and I have some of my friends who are still, having their pending EP3 I-140. But myself, I have interfiled, so I did not receive a receipt yet. But I just wanted that clarification.
Yeah, a lot of people are still waiting. I think, we haven't witnessed a single receipt as well so far. So.
Yes, correct.
Thank you.
Yeah, thank you so much.
Thank you
Thank you.
so much
You're
for
welcome.
calling. Yes. So we have one more caller on the line. Let's take the call. Hi, who is on the line?
Hi, my name is Vamsi.
Okay.
Hi, Vamsi.
Yeah, Vamsikar, you can talk to Janetha garu.
Okay. Thank you very much. Good afternoon, ma'am. Yeah, actually, I'm in the process of applying my green card. Actually, my priority date is 2011 April, and in 2012 I left USA, and I came back in 2016 to a different employer, and then I filed my 140 with him, and then I started filing my 485 and adjustment of status application and everything. Okay. And back in October, we received the fingerprints. Okay. I submitted my fingerprints and everything in October 2021. And then in January, like the January 2nd or 1st, I received a letter from the USCIS saying like my visa is regressed case, like a notice for file transfer for visa regressed cases. Technically, what they mentioned to me was there is no visas available, and they are transferring my case back to National Benefit Center. That is where I got stuck from the past couple of months. I'm trying to reach USCIS. I think my attorney is trying to reach to USCIS, and we are waiting for some call, get back call from them. So I just want to know, like, what is this visa regress case, and what are my options of getting my green card now?
Was it under the EB2 or EB3?
It is under EB2, ma'am.
Oh, EB2. And what is your priority date, you said?
My priority date is April 2011, which is current.
Which is current. Then, I think there is a small miscommunication might be. Did you try to port the previous priority date from a different employer to this I-140?
I do.
Oh, yeah. Maybe, what I would recommend is, make sure that you check the I-140 that was filed along with the adjustment of status petition to make sure. Sometimes, you assume that, okay, the date got ported, and then attorneys, because, they have day in, day out so many cases, they don't pay attention as well unless until you let them know looking into your priority date. So if you already well aware that, the priority date on your I-140 was technically ported, and that's what the copy which was submitted to the USCIS, then definitely there need to be some inquiry done here, because, once it is current, they should not send such kind of notification. I think there is a small communication gap on that priority date, I'm guessing. I don't know.
Yeah, actually, I think you got it right, madam. The reason why I'm saying this is when my 140 was ported, right, I received with a priority date of 2020, basically. Then I worked with my attorney, and then we reached out to USCIS again, and then we ported back to my old employer's priority date. The 140 which I received is with the old priority date, and the 485 is also having the old priority date in the notice which I received. So, yeah, that is one thing we should still check back. Actually,
was a copy of the correct I-140 approval, which has the old priority date, the 2011, was submitted along with the AOS, or no?
Yes, I think, they did.
Okay. Maybe one other reason would be, I'm guessing, if they ported the date, technically, it should reflect, and then they should honor, unless and until that particular I-140 was revoked for any fraud or misrepresentation. You had to be aware of that one too. You had to check with your previous employer, was any of those things was done. Though it's a voluntary withdrawal from the company, that should not affect. But, if the I-140 was withdrawn as part of the fraud or misrepresentation, yes, that might affect. So you have to, cross-check with them if they can give you some kind of answers. Or maybe, try to communicate continuously with the USCIS and then let them know, hey, this is what it is. And then the date technically got ported. So.
Yeah. I did receive my EAD card, though, like... I did receive my EAD card and advance payroll. So that's where I'm yeah.
That is really something. I think, you should definitely engage in, maybe a congressional intervention for this one, so that way maybe you might get benefited for at least this year numbers.
Okay. That's it. Okay. Thank you very much.
You're welcome.
Yeah, thank you. Yeah, madam, we have one more caller on the line. Let us take that call as well. Hi, who is on the line? Hello.
Hi. Thank you for the call. Can you able to hear me?
Yes. Go ahead and you can talk to Janetha garu, please.
Hi, Janetha garu. Thank you so much for the community and arranging and helping the people. Really appreciate. Thank you. I have a quick question regarding EB2 and EB3. What these things right now going on? So my both I-140 approved EB2 and EB3. What I did, I downgraded from EB2 to 3 in November 2020. Priority date is in September 2013. I'm not in current either EB2 and 3. I want to change the job which I received the offer now because I've been with the same employer and the same client since I received my EB2 140, right? Same thing. But now I received the job, another offer. I wanted to switch. If I switch to the new job, can I enter file after I join the new company? Because if I'm going to join the new company, that means I have to file 485J with the new company, right? And that, of course, why I'm going to do that, because I received EAD and AP already from EB3 category, right? So that I already have it. So I want to move to the EAD, change the job. Of course, I have to file 485J. But after that, if my date is going to be current, can I interfile? I know I don't think so I can refile or right, because EB2 is going to be different employer. But can I interfile after I join the new company?
See, technically, the interfiling states that, you have to send out a 485J confirmation to do that. So, once you move to a new employer on the job portability, because 180 days passed after your, the EADs got approved and the 485 filed, 180 days passed. So based on the portability, you will be moving. So I think you can do, an interfiling based on, but again, when you look back, it's just, by doing the interfiling, the job portability, we already did, which was, when you moved. But again, now this should be a confirmation or job portability. Yes, I think you technically can do. What's your name, you said?
Yeah, my name is Prakash.
Prakash, yeah. I think you can do, Mr. Prakash.
But Janetha, interfiling is I'm going to do based upon EB2, right? Because interfiling, right?
If you have the dates available, if the dates are available.
Yeah. No, yes, if the date is available, I can do that. But what I'm saying, the employer, EB2 employer was different, right? If I'm going to change the job, the employer is going to change. So can I still interfile? I'm a little bit confused. So I'm sorry. I don't know whether I'm explaining you correctly.
No, I got your point, Mr. Prakash. So this is a little bit gray area, but what I would say is you can definitely try. The reason I'm saying that is based on the 180-day rule, you are trying to say that you are doing a portability or that you are already did a job portability, right?
No, I did not.
So
I did not.
You did not?
No, I did not.
Okay, then, if you are eligible for that, if you are planning to move on those lines, then, the only requirement for the interfiling is that, there should be a bona fide job offer, right? And then by doing a job portability, the other employer is already saying, yes, this is in the same or similar position. and then that is already available. So, I mean, I have never done this specific thing, but I guess my opinion would be, looks like you should be eligible to do that.
I see. Because the 485J I'm gonna file because I'm gonna marry to the EB3 I-140, and that's how I'm moving, right?
Mm-hmm.
And interfiling to EB2, that is with the old employer. That's what I was like so confused, because how the USCIS is gonna find out that you don't have EB2 with this employer, they have EB2 with the previous employer. So
because
how can you?
Yeah, I mean, that, as I said, it's a gray area, and as I said, I'm acknowledging that I have never come across this particular scenario. Sure. But as for the interfiling, as it's only the confirmation of the bona fide job offer or the job portability, I mean, that's what they are saying you had to file along with the interfiling. So when it is the same or similar, like let's say if your EB2 and EB3 positions are two different things, then, I mean, I'm assuming it's the same because, as you said, you downgraded. So technically using the same label, same I-140 position title. So, if it is the same or similar employment, of course, it can be done. That's what my interpretation is.
I see. Thank you so much. Thank you.
You're welcome, Mr. Prakash.
Thank you, Prakash. Thank you so much.
Thank you so much. Thank you.
Yeah.
Take care.
Yeah. So, madam, I think almost all the topics, all the important points have been covered as far as we know. So, also, can you tell us more guidelines about interfiling as per the USCIS?
See, I mean, USCIS, I think in January of 2022, they came back and said that, as more numbers are available, so, they want to make sure that most of the people are trying to, instead of, refiling the whole case, they are at least advising to do an interfiling. Because if you do a refiling along with the fee and all, it's whole different case, and then a lot of resource time goes in there to adjudicate the whole thing. So when they do interfiling, at least I think half of the time would be cut out on those lines, and then they can save some of the resource time. Maybe that is another thing that they clearly came up with some guidelines. I mean, interfiling is nothing new that they just came and then announced it. It is always there. I mean, I have done a couple cases in 2013, I believe. But again, it's kind of they never had a streamlined process. Then it's kind of sending them an email and then the whole file stating hey, this is what it is. But now USCIS only came forward and kind of announced it. Hey, this is how you need to do it. Send it to this particular. They specially created a separate address for these whole interfilings. But however, though the filings are happening, as I said in the same call several times, that we. I mean, USCIS is not acknowledging the 485Gs that were being filed as part of the interfiling. Till date, we haven't witnessed even a single receipt notice for the interfilings. So, we are waiting on several of those. Not sure how USCIS is going to handle that one. But yes, as they provided a specific guidelines, how one should do, and then what should go as part of the interfiling. They said that technically submit it with a completed 485J. So which comes under kind of employer saying confirming a bona fide job offer, or it's a portability. So getting the 485s signed by the employer, and then attaching all the 485 receipt notices along with the cover letters, especially for principal applicants, and also for include all the derivative beneficiaries details as well in the cover letter, and their 485s and stuff like that. That's what we are doing, and then doing the interfiling. So, and this is all the interfilings go to a specific address that the USCIS created in, and the address is in California. So
Okay.
hopefully it works out, but I mean, so far, even from my colleagues, I never heard anybody saying that, at least they are receiving acknowledgements for the 485Js. So
Okay. Yeah. Thank you so much, Janetha Garu. Thank you so much for all the precious points you have discussed, and you have clarified many friends' doubts today. So thank you so much, and we will go ahead and do one more interview or some regarding any other thing, like whether it may be GC or any H1 or H4. And as of now, thank you so much for clapping all the doors regarding H1, H1B cap registrations, interfiling, and H4 EAD and everything. Thank you so much, madam, for
you're
everything.
welcome, Lakshmi Garu, and the pleasure to be, part of Telugu NRI Radio. Thank you.
Thank you so much once again. Have a nice day. Bye. Andy.
You too. Thank you.
So yes, that was Janetha Garu. So thank you so much for your valuable time, madam, for clarifying all our doubts, and wish you all the very best. And thank you so much for each and everyone who have called today and asked all the valuable questions to Janetha Garu. And see you all in the interview. Till then, bye bye. Take care. Have a nice day. Signing off. Favorite Sowjanya from California.